Good afternoon, everyone. Thank you for joining us today for the Realcomp Legal Update. I'm Karen Cage, CEO for Realcomp. And as you know, there are many mandated changes that are coming along, and our goal today is to explain the recent NAR settlement and what it means for Realcomp, all of you, and our industry as a whole. I'll introduce our presenter in just a few minutes, but first I want to share some other key points. We are recording this today so that if you miss any of it, you'll be able to find it on our YouTube channel in just a few days, or if you have some agents that ask you about the video or how it went, you can direct them to our YouTube channel and they'll be able to see it there in just a couple of days. We're asking if you have any questions that you put them in the Q&A that you'll see at the bottom of your screen. We're going to answer all of the questions at the end. We'll get to as many as we possibly can. And if we don't get to your question, please know that we will respond to it in writing when we send out an update based on all the discussions that we've had today. This settlement will require some major changes to our MLS rules and regs, and we're in the process of updating these documents and plan to distribute them as soon as all of the changes are made. This will be done in advance of the new rules taking effect because we want to make sure that you have plenty of time to review the changes. There's also going to be several system changes that we have to make, and we're working on pulling all of that information together to implement those changes. Once we're prepared to move forward, we'll communicate all of those and what it means to you and what you'll see that looks differently, and we'll communicate that to all of our subscribers. And lastly, we don't have the final approval or sign off yet from the courts regarding these changes, so it is possible there may be changes to what we're explaining today. But we want to make sure to at least share the basic information as soon as possible. Anything that's different from what we talk about today will be communicated with all of you through our normal channels. And now I want to introduce our presenter, Brian O'Keefe. One other thing before I do that, at any point you want to look at the updated information that NAR is publishing, you can go to facts.realtor and you'll find all the information there that they have published so far. So now let me introduce our presenter, Brian, and his associate, Ann Lip. Brian is the founding partner of Lip & O'Keefe, LLC, a Birmingham, Michigan-based law firm. He supervises the firm's transactional, real estate business, and personal planning departments. He has been serving Southeast Michigan businesses, entrepreneurs, and their families for almost 40 years. He is also our general counsel and has been for the last many years. I think it's about 14 or 15 years at this point.
Since 2010, Karen.
2010. Okay, good. I had it. Over the course of his career, Brian has been legal counsel in transactions with a cumulative value in excess of over $1 billion. He received his Bachelor of Arts degree from Michigan State University and received his Juris Doctor degree from the Catholic University of America. Brian's professional memberships include the State Bar of Michigan, Oakland County Bar Association, and the American Bar Association. He's a longtime philanthropist and has served on numerous community and company boards and committees, including I want to make sure I say this right, Brian, Manresa Retreat House and the Young Entrepreneurs Organization. Brian lives in Birmingham with his wife, Robin, and their 4 children. With Brian, as I said, is Ann Lip, his associate, and she'll be answering some of the questions and kind of guiding us through the presentation today as well. So Brian, take it away.
All right, Karen, thanks for the great introduction. Nice introduction. Good afternoon, everyone. I've met many of you through previous Realcomp events, and it's good to be speaking with you all again. Of course, the major talk today is on the NAR settlement in the Sitzer and Morrill cases, but I want to start by giving sort of some background information so we can put this in the proper context. So we'll talk a little bit about the history of antitrust scrutiny of the real estate industry. It goes back more than 60 years. I'll speak a little bit about the genesis of the Morrill and Sitzer cases, the nationwide settlement, the practice changes that are required, the implementation and timing, the changes to the MLS system and forms, which is of utmost importance to all of you. And then I'll answer, I'll talk about what I think are going to be some of the open questions and major shifts that might occur in the real estate industry. And then we'll answer your questions, both the questions that were previously submitted. And as Karen mentioned, if you have questions that arise during the talk, then we can answer those as well. We'll go on as long as we need to. We've got a stop time of around 3 o'clock. So no legal discussion would be complete without a good disclaimer. So we've got a disclaimer here. I'm going to be talking about a myriad of subjects. I'm not going to be providing exhaustive information on all of the subjects. This is a very complicated situation, and it continues to evolve. As Karen mentioned, the settlement won't be finalized, if at all, until November. That's just the way that the court procedures go. So I'm going to be talking about a number of subjects. I'm going to try to be as complete and concise as I can, but it won't be exhaustive of all of the subjects. By entering into this seminar, I'm not providing legal advice to any of you individually. I'm Realcomp's general counsel, as Karen mentioned, and I'm not establishing any attorney-client relationship with any of you. Ann and I are licensed to practice law in the state of Michigan, so our answers are limited to the state of Michigan, not to any other jurisdiction. We're not going to be providing any tax advice during this town hall. And lastly, by participating in this town hall, all of you and all of us are not trying to coordinate the actions of competitors. We're not trying to violate any of the antitrust laws. Rather, we're trying to implement what we hope to be rules and regulations that will help the industry stay out of some of the antitrust issues that it's found itself in the past 30 or 40 years. So first, sort of the history of antitrust law and its scrutiny of the real estate industry. The Sherman Antitrust Act was implemented in 1890, and it was passed by Congress, and it basically provided that any combination or contract or conspiracy between competitors or would-be competitors in restraint of trade is illegal. And the law was implemented, and you may have recalled from history class, to sort of bust up major conglomerates that were forming around the turn of the 20th century. Railroads, steel, the Carnegies, the Mellons, a lot of those big companies around that time were forming major conglomerates, and Congress thought it was anti-competitive, so they passed the Sherman Antitrust Act. About 25 years later, the Clayton Act was enacted, and it also was meant to prohibit discriminatory practices in pricing, in the providing of services, and in the dealings between merchants and competitors. In 1939, the National Association of Real Estate Boards, which was a precursor to NAR, published actually what they wanted to be uniform commission agreements across the entire real estate industry. They had a list of commissions, and of course that immediately caught the eye of the Department of Justice. And in 1950, the Department of Justice brought a lawsuit against the NAREB, and the case went all the way up to the Supreme Court, and it was ultimately ruled, just as you would expect, that fixing prices for even services, the NAREB had tried to make an argument that fixing prices only related to product price fixing. But of course, the Supreme Court and the DOJ disagreed and said that fixing of prices in the service industry also was illegal. So the NAREB dropped their commission schedule and began recommending or suggesting commission rates, which is some of the rules that have carried through, to this very day, and which were the subject matter of the Morrow and Sitzer cases. In 1971, NAR issued what was called the 14 points, which directed local boards and MLSs to stop setting commission rates, whether through the requirements, whether through requirements or suggestions, and they stipulated, do not fix, control, recommend, or suggest commission rates between members. Of course, those were suggestions. NAR tried to implement these suggestions, but it seemed like the industry was sort of continuing along a path of sharing of information relating to commissions. In 1983, the FTC issued what was called the Butters Report, and it continued to point out that the FTC and the DOJ were skeptical of the real estate industry and what they perceived as being price fixing or uniformity in commission rates amongst competitors. So going back to 1983, the DOJ has had its eye on and really back into the 1950s, as I previously mentioned, has had its eye on the real estate industry. In 2005, the Department of Justice initiated a lawsuit against NAR relating to virtual office websites. This is a little off topic, but again, there were some restrictions at the time by NAR on virtual office websites as they started to become more and more prevalent, and internet listing display policies. And the DOJ thought that some of those policies were anti-competitive, so they pursued NAR, and a settlement was entered into that required NAR to implement some policies more friendly to VOW sites and internet display listings. And that was that settlement took effect and ended in 2018. And NAR has continued to support those policies that are non-discriminatory against values. Which brings us to the Sitzer and Morrill cases. In 2017, a group of plaintiffs' attorneys in Missouri representing plaintiffs that were sellers of homes brought a claim against the agents and brokers and NAR and the relevant MLSs and they brought it in Missouri federal court. And they sued for the very things that we're going to be talking in depth about, claiming that the rules that NAR had promulgated and has issued to the industry and have required the MLSs to comply with were discriminatory and resulted in higher than what would be ideal commission rates amongst all seller agents. Quickly thereafter, the Morrill lawsuit was filed in the Northern District of Illinois. It was even more broad than the Sitzer lawsuit, and it was filed against NAR, other defendants, and it concerned the buyer-broker commission rule, the rule that requires cooperation and compensation between agents. This was a large lawsuit that implicated many of the national brokerage firms. It implicated NAR, it implicated many MLSs. And in fact, as you may all be aware, Realcomp was a interested party in this lawsuit. We were not a defendant. So to the extent that people thought that Realcomp was a defendant in the Morrill lawsuit, we were not. We were required to provide some discovery on much of our information that had been put into the MLS, but we were not a defendant. So while those lawsuits were pending, the DOJ and the FTC again took NAR to task about commissions and the rules that it thought that NAR had implemented and required amongst MLSs and brokers and agents relating to commissions and cooperation. And they negotiated with NAR about transparency in broker commissions and agent commissions. The parties got very close to a settlement in 2001, and in fact, NAR believes that they settled with the DOJ, and as one of those settlement precepts, they implemented a rule that requires that buyer brokers not maintain that their services are free. That rule came out of this proposed settlement. But as the administrations changed from the Trump administration to the Biden administration, some of the leadership at the DOJ changed. And so the DOJ withdrew its tentative obligation to settle and decided to not pursue or move forward with the settlement, claiming that the settlement didn't adequately protect the FTC's interests. And so the suit between the DOJ, the FTC, and NAR is still pending. NAR has brought an action to try to enforce the settlement agreement, but the Court of Appeals ruled for the DOJ and claimed and stated that the settlement agreement was not fully effectuated, and NAR has appealed that ruling, and so this case is still up in the air. And what it means for all of us is that the Department of Justice and the Federal Trade Commission are still very interested in the real estate industry. They're still very interested in the relationship amongst buyers agents, sellers agents, and buyers and sellers, and how commissions might be determined, and whether or not the actions of the industry remain anti-competitive. In October, just last fall, in October of 2023, the Sitzer case went to trial. The class was certified. The case went to trial. There was a jury trial. It went on for weeks. And in the end, NAR and the defendants lost, and the plaintiffs were awarded $5.36 billion in damages. The jurors found that the home seller plaintiffs had proved that a conspiracy existed to follow and enforce the NAR policy known as the cooperative compensation rule. So they found that the rule was anti-competitive, and that it had resulted in the overpayment of commissions in the amount of $5.36 billion. And in fact, this was only limited to the Missouri area. So as you can see, it was an astronomical verdict, and it would have ruined NAR and many of the defendants that were named in the case. What it also did, of course, was it prompted dozens of copycat cases. And immediately after this jury award, there were dozens of copycat cases filed around the country. And of course, this is what precipitated NAR to begin to seriously consider settling on what they hoped would be a nationwide basis, because the Morrill case, which was much bigger and included many more defendants and covered a much wider geographic area, could have resulted in a damage award 2, 3, 4 times as large as the damage award in the Sitzer case. I attended a seminar back in the fall of 2023 with a lot of lawyers from around the country, in which we talked about what NAR ended up doing, which is trying to settle so that there is certainty across the country on what the rules and requirements are for cooperative compensation and commissions. So NAR, I think, did the practical. They say in all their materials, and many of you have read it, that they could have appealed these cases. They feel strongly about the cases. They feel strongly that the rules are not anti-competitive, and all of that may be true, but the practical effect is that no one can withstand, the risk of billions of dollars of liability. NAR did have the right to appeal the Sitzer case. They did have the right to litigate the Morrill case thoroughly. But I think for practical purposes and for certainty for the industry and for all of us, that they did the right thing in settling. In March of 2024, they did settle this case. As Karen alluded to at the very beginning, and as I alluded to, the case is not completely settled. there's a settlement agreement, a pleading that constitutes a settlement agreement that has preliminary approval. As I stated earlier, the court in these class actions, the court requires certain procedures. All of the class plaintiffs have to be notified of the settlement, and then the court has to weigh the number of people that opt in, plaintiffs that opt in, the number of plaintiffs that decide not to participate. They have to measure from an equitable standpoint whether or not the settlement is in the best interest of all of the constituents, not just the defendants, but the plaintiffs that are members of the class. They have to be convinced that the settlement agreement is in everyone's best interest. So there's a procedure that has to be followed that takes us from the March time period through the November time period. But if the case is settled, the settlement will resolve claims against NAR nationally. It will resolve claims against all realtor associations, all association-owned multi-listing services, including Realcomp, and it will include all brokerage firms with a principal who is a realtor and whose 2022 volume was $2 billion or below. So that would be, a significant number of the brokers. NAR tried very hard to include brokers that had volume in excess of $2 billion, but the plaintiffs' lawyers would not agree to that. We'll get into it in a minute. There's a way for those brokerages to opt into the settlement, but on its face, the settlement agreement does not cover brokerages with volume in excess of $2 billion in 2022. The settlement amount requires NAR to pay $418 million over a period of time. As you can see, that's significantly less than the $5 billion that was awarded in the Sitzer case alone. So it is in NAR's best interests to enter into the settlement agreement, and it keeps the National Association of Realtors viable for the foreseeable future from a liquidity and monetary standpoint. This settlement covers all persons who sold a home listed on an MLS anywhere in the United States where a commission was paid to any brokerage in connection with the sale of the home. So the plaintiffs will be all of those people that sold a home in the United States and who paid a commission in connection with that. And they'll get a portion of this settlement amount as yet to be determined. Again, these sales are for a limited time period. In Michigan, the home sale period that is covered is from October 31, 2017 onward. The reason that that's important is that the statute of limitations in contract cases is 6 years. So this settlement will include everything back to October 31st of 2017. So people before that time period that might have sold a home that might think that they have a claim will probably be prevented from pursuing that claim against seller agents because of the statute of limitations, not because of this settlement agreement. So the settlement agreement, I think, is designed, although I wasn't a party to the negotiations over the time periods, I think that this time period was designed to include everyone that has a possible claim under a contract claim that is still viable. And for those that have contract claims prior to that, they would be barred from the statute of limitations, barred by the statute of limitations. There are two, as I alluded to a little bit, there are two particular types of entities that are not automatically covered. Those are brokerages with a residential transaction volume over $2 billion in 2022 and non-realtor MLSs. There is a mechanism in the settlement agreement that allows both of these classes of potential defendants to opt into the settlement agreement. Basically, it requires, in general terms, it requires them to agree to the terms of the settlement and implement the rules that are required by the settlement. And then it also requires them to pay some compensation, which is why the plaintiffs' lawyers didn't want them included in the overall settlement. They're going to extract additional funds. So what is the settlement effect on Realcomp and its subscribers? Realcomp is a released party under the agreement and does not have a monetary obligation to pay a settlement fee. What Realcomp must do is it must execute Exhibit B to the settlement agreement. It must do so by June 18th. And basically what the Exhibit B provides is that we will adhere to the new rules and regulations that the settlement agreement requires. Realcomp has in place a mechanism to implement this and sign Exhibit B by June 18th. We're going to be doing that after going through a board of governors meeting to be sure that we do take all of the appropriate steps, but we have a mechanism in place to get this done in the appropriate time. NAR members are covered individually so all the capital R realtors are covered individually unless they are independent contractors or an employee of Home Services of America or one of its affiliates. And that is because Home Services of America and its affiliates have not yet settled the Sitzer-Burnett litigation. They're still litigating that. And then there are also some other non-settling defendants in the Morrill and Sitzer cases that have not agreed to the settlements that have been proposed. And so if you are an employee of one of these non-settling defendants, there might still be the potential for liability. As I said earlier, many brokerages are also covered. If the brokerage has under $2 billion in revenue in 2022, it'll be covered. If it is over that amount, then it has to opt into the agreement. There's a whole process for opting in. So if you're in the audience and you happen to be a member of a broker or a member of a brokerage that has transactional volume in excess of $2 billion in 2022, then you should discuss how to proceed with your legal counsel. So now to the meat of what I think we're all here to discuss. Thank you for being patient on all of the background information, but I think it puts it in context of where we want to go. Offers of compensation are now prohibited from being displayed in the MLS. The compensation fields will be deleted, and participants may not put compensation offers in any other field. Some of the questions, which I'll preview for you, talk about some of these, the variations on this. And of course, everybody's going to be creative. There's a lot of uncertainty, but in general, and there are questions that we even have, and we'll delve into some of these in the Q&A portion of this. But in general, compensation field has to be eliminated, and the compensation cannot be disclosed anywhere else in the MLS. Certain disclosures must be made to sellers, prospective sellers, and buyers that broker compensation is not set by law and is fully negotiable. I happen to agree with most of you out there probably that this has always been the case, that broker compensation was never set by law and was always fully negotiable. But we now have to make this a clear statement. As I said earlier, MLS participants and subscribers must not represent that their brokerage services to a client or customer are free or are available at no cost unless that is in fact the case and the participant is not receiving anything in any way, shape, or form that could constitute a commission. And a written agreement is now required for MLS participants acting for buyers. I'm going to get into this in a little more detail, but that written agreement must be in place prior to showing your buyer the first home. So let's break down in a little more detail the new requirements. The rule says the multi-listing service shall not fix, control, recommend, suggest, or maintain commission rates or fees for services to be rendered by participants. Further, the multiple listing service shall not fix, control, recommend, suggest, or maintain the division of commissions or fees between cooperating participants or between participants and non-participants. The new rules require that MLS participants and subscribers must not represent that their brokerage services to a client or customer are free or are available at no cost to their clients unless the participant or subscriber will receive no financial compensation from any source for those services. And by the way, I think that's going, although who knows what the scrutiny will be on this going forward, whether it will be from the DOJ, from the FTC, or from new plaintiffs' lawyers, or even amongst participants. But even things like taking fees in connection with with some ancillary service might be scrutinized as a disguised commission. So everybody's got to be very careful in this area. Participants and subscribers must not filter out or restrict MLS listings that are communicated to customers or clients based on the existence or level of compensation offered to the cooperating broker or based on the name of a brokerage or agent. So there can be no way in the MLS to be able to filter, sort, or determine which firms are paying higher commissions or lesser commissions, or certain rates of commissions. Participants, subscribers, or their sellers may not make offers of compensation to a buyer broker, or buyer representative in the MLS. Now, this doesn't mean that you can't do this off MLS in private, with writings between the parties, with text messages or emails, or handshake agreements, but it can't be done. It cannot be done inside the MLS. MLS participants and subscribers must disclose to prospective sellers and buyers that broker compensation is not set by law and is fully negotiable. This must be included in conspicuous language as part of any listing agreement, buyer written agreement, and pre-closing disclosure document if one exists. It conspicuously disclosed in writing to sellers and obtain the seller's authority for any payments or offers of payment that the listing participant or seller will make to another broker, agent, or other representative acting for the buyer. This disclosure must include the amount or rate of any such payment and be made in writing in advance of any payment or agreement to pay. So if you're a seller broker, seller agent, and you go to your seller and you say, here's my listing agreement. I'm going to have a commission. I want a commission of 5%, and I'm going to pay 2% of that to in order to sell your home and to generate a lot of interest in your home. I'm going to pay 2% of that to the buyer agent. That all has to be in writing and understood by the seller. It's not prohibited. There's been some misunderstandings and some questions. It's not prohibited. It has to be disclosed, understandable, and done in a way that all contracts have to be done, arm's length, and in a way that is fair to both contracting parties. The written buyer agreements must have a specific and conspicuous disclosure of the amount or rate of compensation that the participant will receive, or how this amount will be determined, to the extent that the participant will receive compensation from any source. The amount of compensation, it has to be in a manner that is objectively ascertainable and not open-ended. So it can't be something that says, I'll get whatever, I'll take whatever the seller's agent is willing to pay me. It can't be that. We'll get into this in a little more detail in the Q&A portion of this, but it has to be objectively ascertainable. What that means, again, this is where lawyers have a field day on both sides. What is objectively ascertainable? It's not in the settlement agreement. It's not defined anywhere, and it's going to be up to the future of what all of you as agents and brokers and your advisors and representatives, what you all determine this to mean, and from an MLS level, we're going to have to, because the MLS is responsible for enforcing all of this, we are going to have to start taking some, we're going to have to start making some rules regarding what is objectively ascertainable and start to try to determine how we're going to view this.
And Brian, I just wanted to say one thing about the written buyer agreements.
Sure.
Because I've seen in the Q&As a lot of questions about when it's required to be in a buyer agreement. And the magic language is when you are working with a buyer, and that's going to be the term of art that determines whether you have to have a written buyer agreement. We can talk more about that later, but that's the standard for when that applies, working with.
And I think, Anne, in NAR's language, it's before they tour a home.
Yeah, it's if anyone wants to pull it up, it's on facts.realtor. There's a list of FAQs. I'm particularly looking at FAQ number 52. And they have a couple paragraphs on what working with means. You know, when you're working with a buyer versus just talking to a buyer on behalf of a seller, it's not the same thing. So there's some good explanations there.
Right.
Just wanted to bring that up.
No, that's thanks for the input in. And yes, so it goes back to, I think NAR is saying before you tour a home. So if someone's sitting with you in your office and you're looking at, you haven't really entered into a formal agreement yet, but you've got a prospect that you think you might represent as a buyer agent, and you're looking through Realcomp's, the various resources, and you're talking about some homes, you don't need to have an agreement at that point. But if you're going to start actively acting as an agent with the buyer, you've got to have a written agreement. Which segues into the next point. The agreement can't provide, you can't take a commission or compensation more than what you've said in your written buyer agreement. So if you say to your buyer, I will not take a fee in excess of $10,000 in connection with representing you as a buyer, and then along comes a seller that is very interested in selling its home and offers you as the buyer agent something in excess of that, you're going to have to go back and get an amendment to your contract that provides that you're going to, instead of taking $10,000, you're going to take $20,000 or whatever the number happens to be. You can, one of the questions, again, I don't mean to get to all the questions yet, but one of the questions that we received was, can you have multiple agreements? You can have multiple agreements and you can have amendments to agreements, but it has to be, it's contract law. You have to have a contract and you have to have it be in writing, and it has to be understood by the party that you're dealing with, your customer. And there has to be a conspicuous statement in the various forms that broker fees and commissions are not set by law and are fully negotiable. Here's another interesting point to the settlement that everyone should be aware of. On unlisted property, MLS participants acting as a buyer or tenant representative or broker shall disclose that relationship to the seller landlord at first contact for that buyer tenant, and shall provide written confirmation of such disclosure to the seller landlord not later than the execution of any purchase or lease agreement. So again, if you're going into if you have a buyer and you're going into so-called FSBOs, then you should have a document that either prepared or that you can prepare quickly that would disclose to that seller that you've got a contract with a buyer and that you'll be receiving some compensation. The settlement expressly provides that sellers may communicate seller concessions such as buyer closing costs via the MLS, provided that such concessions are not conditioned on the use of or payment to a buyer broker. So we may be seeing new fields in the MLS to facilitate this option in the future. Karen's been following this closely. There's already been some information that we've been receiving where certain entities are going to be adding new fields, and we're certainly at Realcomp going to be considering whether we should have a similar field in the MLS. So backtracking for a moment, here's what we're looking at as far as the settlement goes and the timeline for implementation of our practice and policy changes. As I said, the settlement agreement was entered into in March of 2024, a few months ago. As a result, NAR withdrew a lot of motions it had pending for in the Sitzer case. They had some appeals. They had a motion to set aside the judgment. They withdrew all of those, and as a result, the plaintiffs filed a motion for preliminary approval of the settlement in April, and the preliminary approval was granted on April 23rd. The approval process and the settlement agreement requires, as I said, for certain action to be taken on June 18th. This is the deadline in our case for us to execute Appendix B, and Realcomp is planning on doing that subject to board approval.
Brian, before you go beyond that, that's probably one of the biggest questions we're getting so far.
Okay.
Why would we agree to the terms of the settlement when it hasn't been finalized yet? And I think that that's really important for you to explain while we're looking here at this timeline.
Okay. Well, it's important. The reason we're doing that is because that's what the settlement agreement provides and requires. The reason it requires that is that the plaintiff's attorneys do not want to send out their notice to the plaintiff, their claims forms to the plaintiffs, asking the plaintiffs to opt into this class before they know that NAR, the MLSs, and the brokerages are going to be play ball and implement the rules. So it has to occur on a certain timeline. If we don't do this, if we and others don't do this, and if the rule changes are not implemented at the time periods required, then the plaintiff's lawyers will not send out the claims notices, and the settlement will fall apart. So
and what is the downside to that? That it may start all over again.
Well, the downside is that if this doesn't settle, then NAR will be subject to the Sitzer judgment of $5.24 billion. All of the other defendants in the Sitzer case will be subject to the liability that they were found to have liability for in that case, and the Morrill case will proceed to trial. So if this settlement falls, and the settlement, although in these kinds of cases there's a high level of certainty, upwards of 80-90%, this is not certain to be settled. The other downside is if it doesn't settle, we might, and we decide that we're no longer going to cooperate, and by we I mean Realcomp, MLS, as well as the other covered parties, then we can rescind and repeal these rules. But that would be, I think, disastrous for all.
and because that opens us up more to, this is my answer, to the DOJ, who's already looking at it, and to the attorneys that are looking at it. Is that
yes? We'll be back to square one. All those copycat lawsuits that I mentioned earlier would presumably go forward. The rule that's been so beaten up would obviously remain in effect, and would open up everyone again to all of the potential liability.
And it could be that instead of going for NAR as a whole with everybody, they could come after MLSs individually. Is that accurate?
Correct. That's what a lot of those copycat lawsuits were naming other. We were not named in any of the copycat lawsuits, just for clarity of our audience, but a lot of the copycat lawsuits named other MLSs that were not named in the Sitzer or Morrill cases. So other brokers, other MLSs were being named in these copycat cases.
And one other thing that I just want to mention, because I'm watching it go by quite a bit.
Sure.
Everybody's talking about the Northwest MLS in Seattle and how they said, no, we're not going to accept this. They happen to be a broker-owned MLS, and so they are not a realtor-owned MLS, so they're not automatically covered by this. So they had other options they had to make, one being financial and one possibly being financial with an individual communication and negotiation that they have to make on their own. So they're not covered by this. So while it seems like, it could seem like to a lot of people, well, let's just do what they do. They're in an entirely different situation than we are, because we're owned by realtor boards and associations. Therefore, we're a realtor entity, and we're in a position where we can agree to this and not have any future liability, maybe, depending on if it gets settled. But Northwest MLS is going to have to either pay, and I think you probably saw it, those that have read it, well over $3 million, or they have to negotiate a settlement on their own.
That's all accurate, Karen. And Northwest MLS felt like they had some rules because they were broker owned and not subject, therefore, to all of the precise NAR rules that association owned MLSs have been. They felt like a lot of their rules had ameliorated against some of the risk that they have over these lawsuits. So I think they measured the required payment versus what risk that they think they might have going forward. I personally think that they're making a mistake, to tell you the truth, but and that they probably should have opted in, but they know better than I do, and they've got lawyers counseling them, and they feel like their rules that they had in place were not so easily challengeable. So that's, I think, the measurement that they made, the judgment that they made.
Yes.
And I just want to jump in. I'm seeing a lot of questions that are just quick for me to answer unrelated to this. The smaller we are signing would be executing Appendix B. The smaller brokerages have an appendix, yes, that they have to sign. It's Appendix C. And the non-realtor MLSs would be Appendix D. I don't know, that keeps coming up, the smaller brokers.
I think that's up here on June 18th. So right, for our audience, on June 18th.
Yes.
So if you're you have to pay attention to this and be sure that you know how to implement this, or get your lawyers involved. If you're a broker under $2 billion, if you're a broker over $2 billion, no, if you're a broker under $2 billion, you have to execute Appendix C. And if you're a non-realtor MLS, you have to execute Appendix D. All of that by June 18.
And all of this is on that website I mentioned. It's www.fax.realtor. And these appendices are there with a separate set of instructions for each appendix. So you'll be able to see,
right,
what you actually have to do. Like, there's very clear instructions who it has to be emailed to.
Basically, it has to go to plaintiffs. It has to go to two of the lead plaintiffs' counsels, and it has to go to NAR. But you'll see, Ann's absolutely correct. They lead you right through how to implement it. But June 18th is a very important date for all of us.
Thank you. So even though these rules aren't taking effect yet, and even though it's not settled yet, there is a deadline for us to say, yes, we agree, or no, we don't agree. So what happens, Brian, if we sign this and something changes between now and the actual settlement? Well, they sign off on it.
Well, the only things that could change, if there was a change required of all of the defendants, there would be a timetable and a very clear process on how to do that. So if for some reason NAR and the plaintiff's lawyers have a certain additional things that they want to implement, we will all be given an adequate time to respond. The only other thing that could happen would be that the settlement doesn't either A, get approved, or B, somebody withdraws from wanting to settle, in which case we're back to square one. And we're back in this mess of the prior to the settlement, where there's dozens and dozens of lawsuits going on across the nation without any certainty as to when they'll go to trial and what the liability might be.
I think, Brian, that you need to talk again about brokerages and what they need to sign. There's a lot of questions popping up and a lot of people are not understanding. So any brokerage that has under $2 billion in sales in 2022, is that
Yes,
correct?
correct,
Must sign Appendix C.
correct,
That, because anybody over that, they have to negotiate something else.
correct. They have to opt, they have to both, they have to do two things. They have to opt into this, they have to opt into this agreement. And then they have to either pay there's a formula for what they need to
Right,
pay.
right.
Or they can go to mediation and argue as to why they should pay less.
Okay.
Is there a way for me to like shoot that website to everybody, like to just?
We'll publish it, Ann.
Okay,
We'll
okay.
publish. I see it that it's there. And it's very easy. It's just www.facts.realtor, REALTOR, but we will publish it.
So
So
just
any brokerage that has less than $2 billion in sales thank you, Fran, in 2022 needs to go to that site and get that appendix and follow the instructions that are given there.
yes, exactly right.
And we're not, what if an associate broker, we're talking about the actual broker of the firm, of the
Yes.
participating firm.
That will cover the entire brokerage.
Okay. Got it.
So very good. So June 8th, so everybody, that's critical date. June 18th, Appendix C, there's a methodology, describes how to do it. You fill it out and then you send it to, there's email addresses. They're basically the two plaintiffs' lawyers and NAR need to get this.
Got it.
Okay. And just to be complete, the non-realtor MLSs need to execute Appendix D, and all these appendixes basically say the same thing, that you're going to be subject to the settlement agreement. You're going to agree to these new rules and regulations, et cetera, et cetera.
And I think it's important to point out when we talk about a non-realtor MLS, we're not talking about an MLS that has non-realtors as participating in it. We're talking about the ownership of
Yes.
that MLS. And Realcomp is owned by 7 boards of realtors. So we are a realtor MLS because of that ownership.
Correct. Okay, so just
Right.
to finish up this timeline, the new policies and rules need to be in place by August 17th. Realcomp is in the process of implementing all of these things, and we're going to have them in place by August 17th, if not before. And so what the plaintiff's lawyers are going to be looking at is, have the parties that are defendants taken these actions. They're going to be following this very carefully. If enough do not, then they may not send out their claims note. Their claims notice has to go out on August 17th, which is why NAR wants all these things implemented before that date. If these things are implemented on a broad enough basis, then the plaintiffs will send out their claims notice. The plaintiff's lawyers will send out the claims notices, and the plaintiffs will have a period of time to opt into the settlement agreement, which is in the September and October timeframe, with a final hearing on November 26th. So the court needs to give those plaintiffs time to opt in before the final hearing is held, to determine whether or not enough of the plaintiffs are going to agree to the settlement.
And one last question before we move past this, Brian. If the brokerage firm was not established until after 2022, are they required to do anything?
Yes.
Let me look into this. I'm
Okay.
thinking I conflated the appendices.
Okay.
And I want to make sure we have the right answer on
Okay.
this, and that I'm not
You saw
conflating
that question coming up quite a bit.
they're the appendices that apply to the brokerages more than 2 billion versus under 2 billion. I want to make sure we have the
Okay.
right one.
All
And
right.
I'm afraid I said the
We'll get
wrong
to that
thing.
one. Okay, thank you. Thank you.
Sorry about that.
Okay. But I do, I think that takes us through the time, this timeline and why it is like it is. So, recently, as you might all be aware, Realcomp has established its own set of forms. We're not saying our forms are better than the brokers' forms, but we all felt like there should be an option for you all to choose Realcomp reviewed forms. So we've got a set of Realcomp reviewed forms. We are going to make the changes that are required to those forms to implement this settlement. The listing agreements will now have the required disclaimer. Brokerage commissions are not set by law and are fully negotiable. We've also inserted provisions to accommodate commission arrangements, which might not be based upon the sales price. There's some blank lines in some of our forms that will allow you to fill in those sections of the listing agreements with commission arrangements that you might come up with. The buyer agency agreements have been modified to have the same disclaimers, and we are going to continue to monitor NAR and other industry suggestions and recommendations, and we'll update the forms as appropriate. NAR hasn't provided recommended language yet. I think it's a double-edged sword for them. If they recommend language, they might be seen as coordinating competitors again and run into further antitrust problems. So I think they're trying to stay away from that. So I don't know whether or not they'll come out with proposed language, but we're certainly looking very carefully at the rules and the settlement agreement, and we're trying to design forms that will allow you both A, to comply with the rules, and B, have flexibility to determine your commissions and to disclose those to your customers, your clients. So that sort of brings us to what's going to happen in the future. That's a summary of what has happened, what needs to be done, where we are in the process. We're going to go through Q&A in a few minutes and answer variations on what we've already presented. But what's going to happen to the industry in the future? I think that there's some interest in all of this. Unfortunately, this settlement doesn't cover. There are class actions that represent that claim that buyers overpaid for their homes as a result of these commission arrangements. So there's a whole host of class action cases that are still out there where buyers are the plaintiffs and agents and brokers and NAR are the defendants. And what will happen with those lawsuits? Will judges find that the settlement made those lawsuits moot and those lawsuits should not proceed? We don't know that. Will those cases go to trial and be either won or lost, requiring further changes to the industry? Unknown, big unknown. So there's more uncertainty on the horizon. Will the Department of Justice and the Federal Trade Commission continue their investigation, or will they be satisfied with this settlement? I will tell you this. The Department of Justice feels like any commissions that are shared between seller agents and buyer agents are per se anti-competitive. So they are very tuned into that whole scenario and are not happy whether it happens on MLS or off MLS, because they believe that it both is anti-competitive and it puts the loyalties of the agents in perhaps a compromised position. If a buyer agent is receiving commission from a seller agent or from even the seller, are they really doing the best for their for their clients, the buyer? Lawyers have run into this problem for you all are not alone, because we've run into this problem since the beginning of time as well. We can't have parties pay for our legal fees that are not our direct client. So if a mother or a father tries to pay our legal fees for a son or a daughter, there's all kinds of disclosures we have to go through, and that's a very simple scenario. But there are all kinds of disclosures we have to go through because of who's paying the bills. In years past, in divorce situations, it would often be when women weren't working as much in business. Oftentimes, the husband's money would end up paying the wife's legal fee in a divorce situation, and there would have to be all kinds of disclosures made to be sure that everyone understood why that was happening and, you know, why it wasn't an ethics violation. So the DOJ has tuned into this in the real estate industry, and it's not something that's simply solved. Number three, what's the future of NAR? NAR, I think, did the right thing by trying to settle this on a nationwide basis. They prevented their organization from having to go into bankruptcy. They settled at a rate that they think that they can pay over a period of time without raising dues. But are all of the agents and brokers going to continue to see NAR as a worthwhile partner, a worthwhile organization? That's a question I think still will remain to be answered in the future. What's the future of non-realtor MLS participation? Will non-realtors start to be welcomed into MLSs, even association-owned MLSs? Are there ways to do that? There are ways to do that. Is it good? Is it good for the industry? Is it good for the capital R realtors? Is it good for the MLS? Is it good for home buyers and sellers? Those are things that'll still have to be parsed out. Are there other MLS structures or other competitors that might transpire in the future? Is there going to be a nationwide dump of data into Google or Microsoft or some other form? Don't know, but I'm sure all those things are going to be very interesting as we move forward. And then what's the effect on licensed professionals? Just this morning in the Washington Post, there's a big article on and a very well-written article on what the numbers of licensed professionals might look like going forward. Are the individuals that sell only a home or two a year or represent a buyer in one or two home transactions a year, are they going to stay in the industry? And if they do or they don't, is that going to have a benefit on all of our audience out there that do this as a full-time job? Is that going to be a good thing or a bad thing? So those things are still to be determined. So I guess it's question and answer time.
So let's start. We're going to start with the questions that were submitted in advance. We asked if you had some to send them to us so we'd have a little time to research them. So Ann's going to go through some of those questions and Brian will provide the answer to those, and they may answer a lot of the ones that were sent in today. We're going to try to probably go through this rather quickly because there are 85 questions waiting.
Wow.
Yes. So we need to certainly not, I don't want to go through it to where we don't give the information, but I want to make sure that we try to get to as many as we can, Brian. So if you could keep that in mind, that would be great.
Sure. First, I'd like to say thank you to everyone that listened to the presentation. I hope it was helpful, and we're going to try to answer the questions. We've got about an hour left, so I'm going to get through as many as I can.
Well, I think a lot of them we've kind of already touched on. The first question was, why are we making changes in July before everything's approved? We already talked about that, right. So we can move on. Right. When the settlement takes effect, will listing agents be able to add a comment in the realtor's comment section of a listing on Realcomp that reads something like the following? Please visit this page linked below to access additional important terms for the sale of this property. The link would be to a web page with information about the sale, including any shared compensation offered.
So again, to me, this is a very interesting question, right? I mean, can you somehow get around or still share information on compensation somehow? It has to be off MLS. I don't know that the MLS would even allow there to be a link in the comments section that would be, that would be sort of a hot link that would allow you to go to somewhere where compensation was shared. But certainly I would be recommending to the MLS that we not have any way, shape, or form somehow to get, even below the MLS, using the MLS to get to compensation information. Brokers can share the information on their sites.
Just for their listings, though.
Just for their
own listings.
Yep, for their own listings. Right. You can have, you can compile the data, internally and share it amongst yourselves as you go forward in the industry. but it can't be MLS, can't be MLS related.
And before you take the next question, can you please clarify Appendix C? Because it seems
Yeah,
to be
I
there's
think I misspoke. I think, you know, on Facts.Realtor, it refers to Appendix B as being for brokerages in the general. If you look into exhibit that Appendix C, I think that's for the brokerages over 2 million. I will follow up with NAR. Billion, sorry.
billion.
Apologize about that. I'm going to follow up with NAR to make sure that the other brokerages don't have to sign anything.
Okay, that is key because that's a lot of questions. So we
Yeah,
get that
That's my
for you.
fault.
Okay.
I apologize to everyone about that. I was misleading. I'm gonna get a hold of NAR to confirm that there's nothing to sign for the smaller brokerages. And I will suggest that they label Appendix C as large brokerages instead of just brokerages.
Well, it's $2 billion in sales, not commissions. That question had come up as well. So it's anybody
billion.
over 2 billion in sales,
Correct.
not commissions collected.
Correct.
So that's a big difference. So, and I believe it is if you're under the two, and we're gonna find out for sure. If you have sales under 2 billion, then you don't need to do anything. You would automatically be included in the settlement, is what we think.
Yes.
But we're going to verify that for you because it's not really clear on the site. Okay,
Yeah, it's labeled as brokerages, and I think that should be
Yes.
switched to large brokerages.
okay.
But I agree, that's not as clear as I was bragging about it being. So
Okay, next question.
oh yeah, that's me. Okay, will we absolutely need to show a buyer agency document prior to showing any listing?
Yes.
Well, it's not a matter of showing it. You have to have it.
Before you take a buyer into a home, you have to have a proper agreement.
And there's nothing that says you have to show it to anyone.
No,
However,
no.
somebody questions you, if somebody questions and says, Ryan, did you have that buyer agency agreement? It will be up to the MLS to contact the agent and ask for a copy of it. That
Yeah.
is the way it was explained.
Yes, that's
We
correct.
won't be collecting them all up front, please know. But if asked, then it would be up to us to follow up on that.
And just to be clear, it doesn't have to be sent to NAR. This agreement
Mhm.
doesn't have to be sent to NAR. It doesn't have to be sent
Keep it.
to the MLS. It doesn't have to be sent anywhere. But if there is ever an enforcement action or a question, a ethics question, then that agreement might come into scrutiny.
Right.
Okay, this next one, for a company that practices designated agency, what happens at an open house where an agent who does not hold the listing or represent the seller and is not representing the seller and the buyer comes in? Are they required to have an agreement before showing that home or allowing the buyer to tour the home?
The answer is no. The answer is, so I'm assuming that in this situation, there's an agent that represents a seller and a buyer comes in without an agent. There does not need to be a written agreement between the seller agent and the buyer. If the buyer, either has no agent or is not accompanied by an agent, there does not need to be any affirmative action taken by the seller agent.
There's a lot of color on this particular topic in the FAQs number 57, 56, 61, where NAR goes into a couple different scenarios on that topic.
And the key is that the agent holding that open house at that point is representing the seller.
Correct.
So they don't have to have a buyer agreement because they don't have that agreement yet. They might eventually, but during that open house, they do not.
Yes.
They're not yet working with the buyer. Okay, next question. If a buyer is working with agent A and agent A employs or hires agent B as a showing agent to show homes to buyers, then does agent A's buyer agreement cover both agents?
Oh my gosh.
So this depends on how there's some assumptions I'll make. It depends on how your contract is written, is the overall answer. But if agent A and agent B are employed by the same broker, then the agreement that has been entered into by the buyer should cover both of the agents if they're both working for the same broker, because most of these agreements will be at the broker level. is my assumption. So if broker A has agent B and agent C, and they decide that sometimes agent B is going to go out with the buyer and sometimes agent C is going to go out with the buyer, one broker agreement should cover both of those circumstances.
We probably should check up on that and make sure that that's accurate, that the buyer agency agreement is with the brokerage and that the agents within that brokerage are all covered. Because I
Well,
think
that would
that's
be
what I
how
heard.
yeah.
Yeah, we'll follow up on that one because that's a really good question.
Okay, what will be the penalty if a buyer agent contract isn't signed until after an offer is made on the home that the buyer wants to purchase?
Well, as Karen mentioned earlier, the enforcement is going to be with the MLS. And so Realcomp will work on rules. Through our processes, we'll work on rules just like we'd have other rules to determine what the procedure is for complaints and penalties. So it's still to be determined, but it'll be MLS determined.
And it would require somebody filing. We wouldn't know that.
No.
Unless somebody notified us of that.
Correct.
So don't do that.
How will NAR monitor the activity of buyer's agent in regard to having a buyer sign a buyer's agent contract before ever showing any homes?
They won't.
Same answer.
Right. Same answer.
Yep,
Now doesn't have anything to do with this.
Nope.
For the time being.
Can we be clear on the role of splitting the commission with buyer agents?
Can you be clear? Do you think they're asking as a listing agent?
I think they're asking whether they can still do it. You can split the commission.
You can still split commissions. You just can't split commissions in detail with and through the MLS. You can still have, as I said in the discussion, you can have an agreement with a seller that says, I am going to, on the sale of your home, I will receive a 5% commission and I will be sharing X percentage of this with the agent that brings us the appropriate buyer. The buyer then enters into the contract and closes. I will share, X percentage of my commission with that buyer agent. That can still be done. But as I said, I want to make this very clear. The DOJ still believes, the DOJ has felt this way for many, many years, that by having, and I gave the example of the lawyers, by having a seller pay a buyer, by having a seller pay a buyer agent, by having either the seller or the seller's agent pay the buyer's agent, that is anti-competitive. It leads to whose fiduciary duties is owed to whom, and whether or not it's in everyone's best interest. It's permitted. I don't want to confuse anybody. It's permitted, but I think that the industry is still going to be open to scrutiny with that process continuing to be in play.
Okay, where can seller offered commissions be published? Can we publish them on our brokerage website or on Google Docs or on a recording on our voicemail? Can a link to our website or Google Docs be added in the agent remarks?
So MLS participants may augment MLS data or data feeds with offers of compensation to buyer brokers for their own listings in their own brokerage. It has to be off MLS.
So the question of, can they have a link in the agent remarks on the MLS that leads them to their own website where they would publish that information?
Well, Karen, like I said, that's the $1 million question.
We're still waiting on the answer to that.
We've posed that to NAR. I've given NAR that scenario. I've given them the scenario where if we download into, you and I have talked about this, if we download into Docs Plus all of the closing documents, and in there is our commission agreements that then are available in Docs Plus, is that an MLS controlled, since Docs Plus is part of what we offer, is that an MLS controlled situation where it might be violative of this agreement? So we've got those and some other variations posed to the NAR lawyers, but we haven't heard back.
Okay, so that's going to be a really big part of what we have to report back to everyone.
Yes.
Yep.
And I hope I can get an answer from NAR. If not, we'll pose out some best case scenarios, best practices, and we'll have to go with some of those in the interim.
We'll get answers.
Um,
I think we will.
my question pertains to leasing and property management fees and commissions. Is there anything addressed in the judgment for leasing fees? And I was not able to find anything specific on
No,
that.
I've looked, there's nothing that's specific about leasing fees, but leasing fees, I think the best practices would say that leasing fees are commissions and therefore should not be dealt with in the MLS. They should be dealt with separately outside of the MLS with the landlord and the tenant in separate written agreements.
What plans are in place to make all of our forms libraries compliant with the new law? If we have active listings that were written before, this is a two-part question. If we have active listings that were written before the July 1 law changes, do we need to rewrite our listing agreements?
So right now we have multiple documents from multiple sources in the Realcomp libraries. We are updating the Realcomp forms, and we will have all of those updated and in place by on or before August 17th, which is the last day. We will have them updated on or before August 17th. I don't want to have multiple forms out there where causing confusion amongst all of the realtors and the brokers. We're going to have a new set of forms that will be settlement compliant, available before August 17th. Those will be the forms that you should use once they're available. The current forms you can continue to use until the new forms are available. At the same time that we do have new Realcomp forms, we are going to be under an obligation as the MLS to check all of the other forms that are available from us, whether they're Real Estate One forms or some other forms, to be sure they're compliant. So we're going to have a big process to go through to be sure all of the forms that are available through our MLS are compliant with the settlement, but we are going to do that.
But
what we have, I'm sorry, and what we decided to do is once we get the new rules in place, and we're going to share those rules, as I said, so everybody has time to take a look at it. We're going to send them out. We're going to send something directly to the brokers to say, review your forms. Here's the things you need to make sure your forms do not say or do say, and ask them to do that first, because we have thousands of forms in these libraries. So we want the brokers to take responsibility to look at those and make the changes they need to make first.
Right.
And then at some point we'll have to do that ourselves and get them changed. If they're not changed, then we may have to make the decision to take them down.
Right.
We'll leave that up to Brian.
And the second half of the listing, or the second half of the question is, do we have to amend active listings that were written before the July 1 law changes? Or it's not a law, but it is a settlement. And this is addressed in, I'm assuming she's talking about the listing agreements, not the listings themselves. But the listing agreements, NAR does recommend that you work with your seller to amend your listing agreement with regard to the compensation, offers of compensation terms. With regard to the disclosures that have to be added, those can be a separate document. You don't have to amend the whole thing. And that's questions 37 and 38 on the settlement FAQs. Okay, next one. Sorry, I went. Can the buyer agreement also be an exclusive agency contract, or would those need to be two separate documents?
No, I'm assuming that they can all be in one document. So the exclusive agency contract can have in its terms the arrangements for the commissions.
But normally the exclusive agency agreement is between the seller and the agent, not the buyer and the agent.
Well,
it's a form of an exclusive right to sell. It's just different terms. It's an exclusive agency listing. So I don't know how that would be on the sale side.
Well, the seller agreement now has to have commissions in it too. So you're right. The seller agreement should have in the exclusive agency contract, there should be the seller commission.
Right. But
the seller commission should be fully disclosed as we've discussed.
Right. But
the buyer agreement would be a separate document between the buyer and its agent, and that should also have in it, whatever it looks like, it should also have in it the commission arrangements.
Yes. Okay.
Okay, can a buyer agreement contain if-then language? For example, if the seller offers less than 2% commission, then buyer must pay X dollars or a certain percentage in addition to the commission received by the seller.
So this is a great question. I touched on it briefly in the presentation. The compensation agreed upon must be objectively ascertainable and not open-ended.
Yeah.
So is a either or ascertainable and not open-ended? It can be if it's done properly. So it could be that 2% not to exceed $50,000 or 2% or $20,000, whichever is less. I think there are ways to do that. But again, objective and ascertainable is not defined. So it's going to be subject to future, decision and rulemaking. And because the MLS is going to be the arbiter of this, we will have to consider whether we want to put, we meaning Realcomp, will have to consider whether we want to put some further definitions around open and ascertainable, or if we want to let the industry, sort that out as it goes. But it's a very interesting question. It's one I've mulled around, and we may be able to get certain further direction from NAR as they sort of drill down on these things. But in general, it's got to be ascertainable and objective.
Okay, in the NAR bulletin sent April 29th, 2024 by Katie Johnson, one of the questions in the FAQs was, does this mean that brokerages can have only one agreement with the buyer? And the answer was no. So does this mean that a buyer and an agent may have several contracts signed that cover a variety of scenarios?
And the answer is yes, they may have several contracts signed. And they can have contracts, they could have one contract that provides for multiple scenarios. They could have, as I said, they could have amendments to the contract as things proceed. In the example I gave during the town hall, if you have a contract with your buyer that says I won't receive more than a $10,000 commission to present a home to you that you buy, and then you get an offer, some fabulous offer from a desperate seller that says that they'll pay you more if you can convince your buyer to buy that home. You can take that commission as long as it's disclosed and you amend your contract with your buyer. So it's freedom to contract.
And I think this was asking, it seems to me this was asking, could you have that up front? Could you have a contract with your seller up front that has different terms in it?
I think you can.
Well, especially since now you can't offer the compensation on the MLS, you're not going to be held to it. So there could be different,
Yeah, absolutely.
different agreements. Yeah. That's a good question though.
Right. But yeah, I think the answer is yes. You can have a contract that has multiple scenarios in it, or you could have, I don't know why you do it this way, but you could have multiple contracts with the same buyer that provided for different scenarios.
But you'd have to be very careful that there aren't conflicting provisions. So
Very
if one
careful
says
that they aren't.
better commission, then they're going to say,
Very careful that they're not conflicting, and you can amend your agreement as you go.
okay, this one, just curious why listing agreements are not the contracts affected by the settlement since it was sellers who sued.
Well, the listing agreements are affected. There has to be disclosure that commissions are fully negotiable and not set by law. And the seller's agent should have a clear commission agreement with their seller clients.
Okay.
In writing.
Uh-huh.
I heard MI RealSource will be offering a non-realtor MLS by the end of the year so as not to have any antitrust issues. Does Realcomp plan on offering an MLS to non-realtors as in an MLS just licensed real estate agents? It must be with just licensed real estate agents.
Well, a couple things. The fact that there are realtors or non-realtors in the MLS doesn't necessarily prevent antitrust litigation. In fact, there are plenty of MLSs that are not association owned that were subject to the antitrust litigation. I don't know what MI RealSource is planning, but Realcomp has certainly been looking at and discussing non-realtor access to the MLS. There have been no decisions made. There's been no formal sort of view of whether that's a good thing or a bad thing, but we have been discussing it.
And that's the end of that set of questions.
Okay, well, trust me, I got more. All right. So I'm going to go through the ones that I think we've already answered rather quickly here. First one, what does enforcement of policies look like? And again, we haven't set our rules for that yet. So we're going to have to put that into our rules once we add these new NAR changes. Will agents be allowed to use showing time to communicate with agents who request a showing? What is the compensation being offered by seller? This, again, is one of the questions we have open to at NAR, because since showing time is offered through Realcomp as a Realcomp service, will we be able to use them as a platform for distributing that information? And the answer is we don't know. We don't know yet. Can we add buyer commission percentage or fee to the agent remarks?
No.
No, that's a nice quick one. Will Realcomp?
That one I'm certain on.
Yes. Will Realcomp be adding a new seller concession field for active listings similar to what CRMLS did? Can I first just say I'm impressed with the number of people that have read those articles. We are certainly looking at that, but I don't know. I don't know how to answer that, Brian. It makes me a little nervous.
Yeah. Well, I think it's like a lot of this. This is going to be not just a 1 month or 3 month endeavor. There are going to be ramifications in the industry over this for months or years to come. So I think it will be something that will be on our work list.
Yeah.
To look at from time to time and decide.
Is it just taking compensation and changing the name of it?
Right.
Being compensation, now it's called a concession. I don't know. I don't know. And Brian's job is to protect Realcomp, and Realcomp's job is to protect all of you. So, we will have to look at that very carefully. It looks like such an appealing solution, but it does make me a little bit nervous. Can a listing agent provide buyer agency compensation paid by the seller in agent remarks? So in other words, not the amount or anything. Can they just say, there will be compensation paid? Oh, so you find that funny? The answer no?
I would not do that.
Okay, I would not either.
I think the best practice would be not to do that. I'll just take. There's the old saying that the criminals are always ahead of the police. So creative people, whether it's lawyers or whomever, can come up with scenarios to create. But let's try to do best practices, and that would not be a best practice at this point.
Do these changes apply to commercial real estate? I'm going to say, do they apply to commercial real estate within Realcomp? And the answer would be yes, correct?
Yes,
it may not be outside of Realcomp, but I don't know that. I don't know what those policies would be.
Right.
The settlement is geared at residential.
Yeah.
It is. Okay.
Yes.
But if they have those listings in our MLS, they would still have to abide by those policies. Is that correct?
Yeah, unless you had a separate set of rules for commercial properties.
Okay, we do not. And this question, so actual home sellers will receive compensation. I'm assuming that is the question in terms of the settlement money that gets distributed, and the answer to that would be yes.
Yes, home sellers for the period from October of 2017 through the date of the settlement would receive that opt into
the date of the class notice.
That get a class notice and opt into the class will receive some compensation.
Will we be helping with the change of forms? I think we've covered that. We'll be doing the best we can to help everybody through that. As of what date do we need to have a buyer agency agreement signed, given the lawsuit still isn't settled? I think we have to get off of that piece about the effective settlement date and get to the effective rule date, which is August 17th.
Correct. August 17th would be the best answer, Karen. Yes.
Okay, August 17th. Okay. This question is a great question because this came up in our staff meeting. What about brokers that charge compliance or administrative fees? And they put that in the remarks. Are those considered, I don't know that those are considered compensation.
Are
but I
they,
think we should probably ask that question.
I think we should, I think we've got to answer that.
Okay.
I think we've got to ask that question.
Okay. So we'll need to send that one back to Brian. Because the lawsuit's not settled, oh wait. Right now I provide a copy to my brokerage to prove the commission rate. Is there a solution for that once the commission rate is not on the MLS? Well, that would be the agreement that you would get from the, I'm assuming you're a buyer agent, I don't know.
Yeah.
I guess I don't know, since I don't know what side you're on, but you should have something in writing, and it would be on the PA. It would be on the purchase agreement, correct?
it should be.
It should be in writing, and it should be in writing, and it should either be a separate agreement or on the purchase agreement.
Okay. Because the lawsuit is not settled, since commissions were never fixed, why does this lawsuit exist at all? How do we explain to clients how we get into these waters? Oh, John, no. I wish I had the answer for you, buddy.
Yeah.
I don't know.
I mean, just to say again, without beating a dead horse, I mean, there's been scrutiny on the real estate industry back from the 1950s. Anytime a group of competitors, which all real estate agents are, because they are competing for buyers and sellers, anytime there's any kind of perceived sharing of monies in connection with a transaction, there's scrutiny. And despite the fact that NAR, thought that they were doing the right thing. In fact, NAR implemented many of these rules as a result of consumer protection concerns in the 1990s. A lot of these rules are a result of consumer protection concerns on other sides of this. And NAR thought that they were implementing rules that would help everyone, but sometimes the rules are either misguided or misconstrued or misimplemented, and it results in this kind of problem. So.
Will this information be made available via email? We will flood you with so much information just as soon as we know. And we'll have, what your disclosure requirements are, the disclosures that you need to put on your listing agreements, and so on and so forth. So yes, Eric, we will make sure that information gets sent out to you. Is conspicuous language met with a blank line for negotiated commission blank that you discuss with client and fill in at the hiring meeting? So in other words, I'm thinking you could have a form that says this is, the negotiated commission is X. And so you'll fill it in at the time that you're working with your client to hire them. I would think that would work.
As long as like the preamble to that, negotiated commission is, and that is in bold, bigger font.
Yeah, I'd put it in, as Ann says, I'd put it in bold font, and I'd put it in a box maybe, or bold font in a slightly larger, slightly larger size. I think that's good.
Okay. Will the buyer agreements be permitted to be amended? We've already said yes to that.
Yep.
The settlement wasn't clear regarding what it means to be working with a buyer. I think that was defined as touring a home.
Yes.
I agree that the working with is
Not clear.
It's not super clear, and that's what they came up with. And I think that will be the subject of discussion going forward. Okay. Touring a home was, yes, one of the things that met that requirement. But there's a lot of discussion on this in those FAQs. Let me find the
okay.
We're looking at FAQs number 52. Has a lot of color on what working with means. Okay. And 53 is the one that goes into touring a home.
Will we be able to get a copy of today's talk? Yes, this whole thing is being recorded, and it will be available on our YouTube channel by the beginning of next week. So you'll be able to go there and watch it all over again. How can I? Oh, okay. Brokerages being required to hold buyer agency contracts prior to showing of the first home. How is this going to be monitored? Well, it by you. I mean, it's really kind of self-monitoring until there's an issue that gets reported, and then we, the MLS, would have to contact you and say, we need to see a copy of your buyer agency agreement.
That's right.
Oy. Will the broker compensation amounts be removed from MLS on closed sales once the new rules are enacted? This is a great question, because I don't believe that the settlement requires us to go backward and remove that information on listings that were there prior to the settlement date. Is that correct, Brian?
That's correct.
Okay, but let's talk about why that's a problem. We have to remove those fields. And if I don't have the field, I can't show the data. So that's going to be an issue. We're looking at what we might be able to do by date and so forth, but like right now, where you have an older listing that sold and it said, you know, they were offering $2. Well, that field's going away. And so I won't have any place to put that information. So we have to come up with some creative ideas if we're going to keep that information on the back listings.
Right.
So that's not as easy as it sounded.
No, we might want to have like a static set of data as of August 1 that stays, stays there. And then going forward, we don't have those fields anymore.
Yep, we're looking at what we can do for that. I don't know how valuable that information is for everyone. We'll probably reach out and ask that question, but we're looking at what those alternatives look like. A listing agent talking to a buyer as a customer is not the same thing as working with a, yep, okay. Facts.realtor, okay, we published that for you. So to show any house to someone, they must sign an agreement. What will the language look like in a situation to showing someone a house on the spot? Well, it would look the same. You just have to carry that with you, correct?
Correct. Yep.
You'd have to, whatever your
electronic form too.
That can be electronic.
If you are tech savvy, you could make it an electronic form and have it on your phone.
Good point. Very good point. Okay, this is a long one. So it's possible the selling agent and seller agree to give the buyer agent compensation, and the buying agent enter into an agreement where the buyer also is willing to give the buyer a compensation, as well as the buyer's agent. I'm confused, before showing a home and is unaware that the seller's agent is also giving a compensation. Well, this goes back to
right.
What that buyer agent agreement looks like, that says they cannot get paid more than X.
Right.
Regardless of where it comes from.
Right.
Without revising that agreement.
Right. So if you get approached with that scenario, if you have as I said, if you have an agreement, I'm going to be paid a flat $10,000 fee, but because of the situation, the seller's willing to pay much more, somewhat more than that, then you have to get an amendment with your buyer.
Or if they had said initially they weren't going to pay any, and then they decided they would, you can't accept that. It takes you over. Okay.
Same thing.
Smaller brokerage have to execute the appendix. We're going to have to follow up on that. Matthew says we're going to jail before we get sentenced.
I saw that one.
We are in jail.
I know you probably didn't mean that to be a chuckle, but it did make me chuckle. I'm sorry. How can sellers pay buyer agent commission if it isn't in the form of a concession? Will it be a debit that comes directly from the sellers to the buyer's broker at closing as a seller's closing cost out of their profit? I think it depends on who's paying it. I mean,
now you're setting it up.
yes. Yeah.
As long as your disclosures are there.
Right. Right. I don't know that we can answer that completely. We'd have to walk through what that looks like. When they get to the closing, the buyer agent is being paid by the buyer. That's a whole separate transaction. If the buyer agent's being paid by the seller, then it would be part of just like it is today. Would it not? It would look like it does today.
Yep.
It would be no different. Anne's thinking.
No, I agree.
Okay.
I can see when I look up, that's what I'm thinking.
What are your thoughts on Northwest MLS declining? Well, I think I covered that a little bit. They are not a NAR affiliated MLS.
They believe that they had rules in effect that set them apart from some of these claims. I think that's questionable.
Well,
But
No.
that's a $3 million decision that they made, either right or wrong, either right or wrong.
right, right. And we'll follow that because I've been
Absolutely.
following all of it.
Absolutely.
Will the PowerPoint slides be available? I think we can make those available, can't we, Fran?
Absolutely. Yep.
Okay. How did NAR let us get to this point? When majority of agents did not represent set commissions, is NAR that out of touch with the agent's daily work? Oh, I don't know that I can, that calls for an opinion. And I think I'd rather stick to facts. I'm not sure that I can answer that, Colette. I wish I could. All right. Sorry. Next. Let's see. Where are we? Where are we, Fran?
Do you see Michelle Bradley's question? Do individual broker licensees
Oh,
also?
no, they do not. Individual broker licensees. Again, we're going to get more information on what needs to be signed and by who.
What's the question, Karen?
Individual broker licensees need to sign an Appendix C? And
Oh,
that's
yes, we got to get some clarity on that.
one of the pillars of the MLS was the offer of cooperation. Without it, how would the MLS be different from any other portal with real estate listings? You know, it's very interesting because for well over 100 years, the definition of an MLS is the offer of cooperation and compensation. So this just completely removes that whole definition, which is a little disheartening. But I think, Dimitri, I would say that how we would remain different is, you know, the way we provide the information, the rules, the way that we allow you to get that information in, the other products and services, and everything else that we can provide as a source.
And there's still the code of conduct and
No, ethics.
code of ethics and related matters that I think are very important.
Yeah. If we're going to take out the commission field, can we just substitute the concession field immediately? Again, we're going to have to really look carefully at that because I'm not comfortable that would not get us into trouble. I think somebody said it like this: same horse, different cart.
Right.
Or same cart, different horse, one or the other. Okay. Why did NAR seem to defend or support the buyer agents in this? Using some type of verbiage that the buyers and sellers were fully aware of and such, and accept this agreement. I don't want to speak for NAR. I don't want to speak for why they supported who they supported. I think they thought they were doing the best they could to get a settlement. Oh, she wanted to change that to why didn't they? Okay, I see.
Why didn't they include the buyer lawsuits in this?
Why
Is that the
didn't
question?
they? Oh, it went away. Yeah, why didn't they support the buyer agents?
No, I think they just haven't had the opportunity to settle those cases yet. I think they're hoping that some of these rule changes will do away. The judges in some of those cases will find that these rule changes are enough to do away with the buyer damages that may be claimed. But we'll see.
Yeah, and John says, sounds like their main point was about keeping the offers of compensation, particularly to retain seller choice and to ensure fair housing equity. I would say that's part of it, yes.
Yep.
I think it was also to try to keep the DOJ or the FTC from knocking at their door every couple of weeks. Okay, we don't need that. We don't need that one. We got the website already. There's a website again. Am I expected or allowed to tell buyers as their buyer agent if a specific seller is offering buyer agent commission compensation? If I find out a seller is offering to pay a buyer agent commission through direct communication with a listing agent or sellers, am I allowed to tell the buyers that fact before they see the home? Now, remember, I asked this question in a open forum, and the answer that I received, because I don't ever pretend to do what all of you do for a living, I don't do that. The answer I was given was not only are you allowed to, you need to disclose that that as a buyer agent, if your buyer has agreed to pay you X, unless you collect that money elsewhere and you learn that the seller agent or the seller is willing to pay that compensation, then you have an obligation to share that information with your buyer. Is that accurate, Brian?
Could you repeat the question, Karen?
If I'm a buyer agent and I have agreed, my buyer has agreed to pay me $2. And
Yes,
I learn that the house they're looking at, the listing agent or the seller has agreed to pay $2. Do I have an obligation to tell my buyer that? And I believe I do.
I
because
think you do. Yeah,
They then wouldn't have to pay me.
right,
Can't collect more than what's on that agreement.
correct.
Okay.
Right, you have to change the agreement, yeah.
You change the agreement to be $4.
But-
You could change the agreement to be $4.
Right,
Or
in
you
which
could,
case you'd still have to tell them.
right, or you could say to the, absolutely, or you could say to them, you know what, I appreciate you paying me $2, but I'm gonna get that from the seller. So,
Yep.
you know,
Can commission forms requesting commission from seller by buyer agents be sent via remind? That's, again, we are looking hard at those questions on what we can have available and what we can't. And that's probably our number one question. And Brian and Ann are both working to get that information as soon as possible so we can get that to all of you. Fax.realtor.com. No, not fax.realtor.com, just fax.realtor.
yep, fax.realtor.
Are we cutting out a lot of buyers? They can barely afford a mortgage payment, let alone paying commission on top of that. Well, that is a concern. It definitely is a concern. But I don't know, I don't really know how to respond to that. I can say I hope not, but I don't know.
Well, that's why suddenly this concessions field has become such a,
I
you know,
know.
become such a topic of
I know.
conversation. Instead of paying, commissions, can you induce a buyer to buy a home because you give concessions?
Right. Well, we need to submit a buyer agency contract to listing agents before showings. The answer is no. They're not obligated to provide that to the listing agent. Is that correct?
Correct.
Where will these be made available to sign? As soon as we figure out what you need to sign, they're all available on Backstop Realtor, and we will let you know that. Thank you, John, for including the URL. And again, we're back here, a brokerage that started in 2024 doesn't need to do anything. We got to get all that information together, who needs to sign what, and we need to get that out as quickly as possible. If the commission is not listed in the MLS, how should it be communicated to the cooperating broker? There are ways.
Through conversation, through email, through meetings, through sharing of the contract.
I did see another related question in there. If they asked if it could be shared through showing time. I'm guessing you guys have like a messaging system through showing time.
Yes, and we don't know the answer to that either. That was where I said we had to find that out too.
Right.
Time is provided by Realcomp as a Realcomp service, so we don't know if that's to be allowed or not. So we need to check into that one. No, we didn't get that yet. We don't know that yet. Chicago has a broker owned MLS. They do. Need to figure out their solution. Yes. How will this new rule affect buyers using VA and FHA loans? Didn't we just recently see something about that, Brian?
Well, Ray was posing some questions about FHA and et cetera, and how it'll affect those things. Some of those things are factored into how the FHA, et cetera, computes sale price versus loan amounts. So it's gonna trickle down into that area for sure. So concessions can affect those ratios.
Yeah, there was something else that was recently published about that. Could you make a note on that one for me, Fran? That I need to look that up, because there was something else that NAR just published, some victory they had on
Yeah.
how those will be handled.
Okay.
There
Right.
is some FHA guidance on that Realtor. I have not read it.
Okay, okay, I'll look there. Thank you, Ann.
It's toward you gotta scroll down, but it's there.
So is our date to make buyers sign an agreement before showing a property June 18th or August? It would be August, correct?
It is August, yes.
In the case of Anywhere Realty where they settled their own agreement, where their brokerages still need to execute, again, we need to get all that information together. I think they've already signed their own agreement, though, the Anywhere brokers,
Yep.
I believe they have. Brokers under, so the broker is, are all these documents only in Remind? Matthew, I'm assuming you're asking me if we'll put them, all the new documents in Remind and in Transaction Desk. We will put them in both. But I will tell you that Remind will have them up in a matter of a couple of days. Transaction Desk takes much longer, but we will make them available in both of those places. Virginia will get you an answer to that question. That's the number one question I'm seeing. Who has to sign what? What happens to the forms libraries such as Lutar, Arvid? I don't know that Lutar has their own forms library, but if they do, we will work with all of our shareholders to get that to make sure that they are up to date and changed. Sellers paying. But the seller is paying the seller's agent, and it's the seller's agent that's paying the buyer agent a portion of his or her commission. Am I correct? I think those have been kind of separated now, have they not, Brian? Now the seller has to agree of what they will specifically pay to. It's not the listing broker any longer that says, I'm gonna get $2 and I'm gonna give one of those to the buyer agent. Is it not now the seller who determines what's going to go to the buyer agent specifically?
No, the seller's agent has to disclose to the seller what's going to go to what's going to go to whom.
It should be in the listing agreement.
Should be in the listing
Okay,
agreement.
but the seller has to agree to that.
Yes, the seller can say, I'm paying a 6% commission, but it also has to say he or she also has to understand that 2% is going to the buyer agent and 4% is going to the seller agent, or vice versa.
Okay.
It's fully negotiable.
Yeah, and it's fully negotiable.
So yes, the seller can dictate it in a sense, but it's negotiable.
Craig, when will the new forms be released? We don't want to put them out there too early because we don't want two sets.
Correct.
So we want to wait until closer to when they're going to be used, and we can remove the old ones and make the new ones available.
Right. In the meantime, you can continue to use the ones that are available in the forms library, whether they're Realcomp or otherwise.
On the buyer agency agreement, could they write the buyer is willing to pay up to a certain commission to cover yourself? Is that considered open-ended, Brian?
On the buyer agreement,
Yes,
you could say up to.
you could say up to, so that's not open-ended.
I don't think so.
Well, if there's a formula, some sort of formula up to that amount, like it can't just be, anything up to 10%, depending on what they're feeling like that day. I think you could say,
it could say
3% of the sales price.
right,
Up
3% of the
$10,000.
sales price up to $20,000 would be fine.
Okay.
As long as there's a real formula.
The date for Realcomp to take compensation off of the MLS, is it June or August? You left out July. Shelley and everyone, it really depends on while working with our vendors, when we can get this done. You can imagine that the large vendors like CoreLogic, who brings us Matrix, which is your RCO3, has many, many sites that they have to make these changes for. So if they came to me and said, your site has been chosen to have this change made as of July 21st, I might not have a lot to say about that, because there's a lot of us and we all have to have the changes made. And so we have to, we're going to have to be a little accommodating for that. So while it may not be the actual deadline, it'll be before. We'll have to do it when when it's our turn to have that change made.
But the deadline is August, the deadline is, to be clear, the deadline is August 17th.
Correct. Ramifications for the brokerage and realtor who does not comply. This one I find interesting because I think you said, Brian, that when you read it, it says, if you publish something you're not supposed to, we're to remove your rights to the MLS.
That's right.
I'm thinking that's pretty harsh.
That's right.
But that's what the new rules say.
So it's going to be on the industry to govern itself.
Correct.
And it's going to be on the MLS to mediate the disputes.
Right.
So if you have, if you get into commission, so for the attendees, the participants, if you get into disputes about commissions and one party complied and another party didn't comply, then, you're going to bring that to the MLS and there'll be some mediation of that dispute and an outcome. Along with, I presume, penalties or other issues. Up to and including, which would be the most draconian, being tossed off the MLS.
And that's, they don't say you work your way up to that. That's the punishment
Right.
that they have spelled out.
Right.
Settlement specifically states no methods of circumventing the rules will be allowed via the MLS. Yes, John, that is accurate. And some of these suggestions that other MLSs are making make me a little nervous about that. Like the concessions. Like I said, it seems like such an easy solution, but it's, to me, the same thing with a different name. So I don't know. I don't know if that'll be a route we take or what NAR will say about that. A realtor holding an open house for another realtor in a designated agency company will not have to have an agreement with the buyer. That is correct, Darwin. You're there on behest of the seller. And so during an open house, they're pretty clear on that you don't have to have an agreement with the buyer. Okay, Brian, can you share compensation info to buyers agents on an email or a form that they may request a showing on your listing separately from the MLS? So if they email you and say, I want to show 123 Elm Street, are you able to email back? Yes, you can show it and we're paying $2.
Yes.
Okay.
Absolutely.
Can the buyer agreement say up to X%? We've said yes to that, correct?
As long as it's it can't just be open-ended up to, there has to be some, you can't just say up to 20,000. It could say 5,000 if the house is between 100,000 and 125,000, you'll pay me 5,000. If the house is between 125 and 150,000, you'll pay me 10,000. It's got to have just up to what and why would be a little problematic.
Yes. Anne, are you going to email us about the small business needing to file appendix C? Yes, we'll get that to everyone.
Yep.
Told we could state seller to give X% or X dollars back to buyer in concessions in the MLS. Seller to give, well, there we go. That's back to the concession thing. We don't have that field. And right now you'd have to put that in remarks. And I don't know that we have adopted that. So I'm going to say no for now, but
No
we're
for now.
looking at that.
No for now. No
Yes.
for now.
Any update on the Pulte proposed lawsuit for overpayment of buyer broker commissions? I don't know anything about that.
I don't have an update on that.
Okay. Is the agreement written per home? What if the buyer doesn't want to go into a relationship? Well, if the buyer doesn't want to sign a buyer agency agreement, then you can't show them home, correct?
Correct. Correct.
It's a requirement.
It's a requirement. But you don't need, I think there's a question in here. You don't need 20 different agreements for 20 different homes. You're working with buyer A, and you have to say to buyer A, I will show you a series of homes. And in the event that you buy one, you will pay me X dollars.
And that's the next question. Does that buyer agreement cover just one home? And does it cover a period of time? I guess it covers a period of time if you write that in it.
It should cover a period of time.
But you would write that in there if you buy a home that I've shown you in the next 6 months or something.
Right. And there should also, I mean, in best practices, you know, just to cover you buyer agents, you should also, there's a whole thing like this, and we do this all the time in commercial real estate and also in commercial business transactions where you're buying or selling a business. If you show buyer A a home on during the time that your agency relationship exists, and then they buy that same home 30 days afterwards, are you still entitled to a commission? So you should have a runoff period the best practice would be to have a runoff period in your agreement that says, if I show you the home during the time that our agency agreement exists, and you buy that home during the time that our agency exists, or for 30 days after our agency agreement exists, I still get my commission. You should have a runoff period to cover yourselves.
Sounds like a protection period to me. Okay, so where'd that go? Can we just put seller concessions, comma, bonus, ask us? I'm gonna say no for now. Is that correct?
Correct.
The bonus is coming off the listing. That isn't even going to be there anymore, so, yeah. Sorry. So the start date to follow all these, well, the final date that all these policies have to start is August 17th, not November 26th and not January 1st.
Correct.
So it has to be by August 17th. MLS has a button that listing agent uploads docs, seller's disclosure. Are we as agents going to be able to upload a commission disclosure? Again, that's like the #1 question we have. So we will get those answers for you. Wondering how busy the professional standards committees will be in the future. That's a really good question, Dave. Is NAR working on changes to the code of ethics? Not that I've seen, but that doesn't mean anything. You know, the professional standards committees are run through the boards and associations of realtors, and to that I say thank you. I don't think I'd want to be doing that in the next, until, you know, while all this shakes out. Doesn't whether the broker practices designated or traditional agency determine whether the buyer agency agreement covers just the named designated agent or covers any agent in the firm? It's a good question, Anne Marie, and we've got to get an answer to that question. What that buyer agency would cover. Is it on behalf of all of the agents within that brokerage, or is it that specific agent? And we need to find that out for sure. What would it take for lenders to finance buyer agency fees, thus avoiding this mess? Well, that's a good question.
There is a section on there's a whole separate financing FAQ
Yep.
on Facts.Realtor.
Okay. Can we show commission on showing time again? We have to get those answers because we're not sure. And I apologize, but we wanted to bring as much information as we could, and we will still get that information for you. 2 questions. Has there been discussion with Fannie Mae regarding rule changes to allow buyers to finance commissions for the buyer's agent? This is not currently allowed. Will VA make rule changes to allow buyers to pay and finance? This is one of the things I believe NAR came out with something on, and they came out with a that they were able to negotiate a change there. So we need to find that. We need to find that because that was a big concern. So we need to find that. And we'll get that out to everybody.
Yep.
Listing agent shares, commission. With the selling agent, still the selling agent has to have the buyer sign the agreement.
Correct.
Yes.
Yes.
If you get paid anything, you have to have an agreement signed by your buyer if you're representing the buyer.
Yep.
Buyer's contract does an amendment. Okay, wait. If the commission that is owed to the buyer's agent brokerage on the buyer agency contract and the seller's offering commission above, yes, we did say
Yes,
that
that has to be amended.
Yep. When working with a buyer doesn't have the money to pay the selling agent and a listing agent is offering commission, can I amend it? Yep.
Yep.
Thank you, John. Agree to not create, facilitate, or support any non-MLS mechanism. Yes, and
Yes.
that's why I'm hesitant for all these things, John. I appreciate that.
Yes.
How will the brokers be notified? I'm assuming that's to our comment about forms. We will be sending you the rules, and then what would need to change on the forms.
Yep.
Okay, Ryan, this question is such a good question. How will the settlement affect the appraisal and comparable sales search process? This is something that has not really been considered too much, and it needs to be. Appraisers adjust for concessions. Shouldn't they just also adjust sale prices to account for commissions? Except they don't get to know what those commissions are. So this is a really big deal. And we have some appraisers that are questioning this. They're questioning it with NAR or Michigan Realtors, and they're questioning it with NAR to figure out how this is going to be handled. I don't have an answer for you yet, but it is a very valid concern regarding those appraisals and what the commission has to do with the prices and the values that you're putting on those properties. So we need to follow that carefully and get as much information as we can. Once commission information is removed, will that impact offer submitted before the removal? So let's say, Brian, on Monday, you present an offer, and on Tuesday, we take the commission off.
Once commission information is removed,
Yeah,
will that impact offers submitted
yeah.
before the removal?
Uh-huh. So
Well,
if they're offering $1 and then the next day that information's gone, is the selling agent, the listing agent, I mean, is still obligated to pay what was published in the MLS, are they not?
yes.
Since it was there prior to?
Yep.
That's tricky. We'll have to make sure we have that, like you said, Brian, a file of that somewhere.
Right. We'll have to have a set in time file.
What are the buyer agent's options if a seller offers 0? No, you'd have to get paid by your buyer.
By your buyer, right?
That's the only option you have. When will testing centers such as PSI for licensing of sales and broker tests? I don't know what that question is asking me.
Yeah, not sure.
If I show 20 houses to my buyer, do I have to have 20 buyer agreements? No.
No.
You already said no. Okay.
As long as your buyer agreement isn't specific to one property.
Right. If it doesn't have an address, good point.
You could contract yourself into a problem. You can always do that.
Seller agrees 1% paid to buyer on the listing agreement. Can that be changed due to negotiations with the buyer agent, for example? Yes. And we've already said yes. Any of that is your verbiage, Brian, is that's contract law. They can change it with the proper permissions.
Correct.
What if the buyer doesn't want to, I think we did these. What if the buyer doesn't want to sign? Can we still show? No, you cannot.
No, the
Violation of the rule.
buyer must enter into some kind of agreement.
Can we set commissions in the buyer agreement as a percentage of the purchase price? Yes. Yes. They can, right?
Yep. As
Yep.
long as subjectively ascertainable, a percentage is fine.
What about co-op sellers, agents? Can before the buyer agency became a big thing, can that be what about the co-op sellers agent can before the buyer agency became a big thing? I'm sorry, I don't understand. Do you understand?
I think they might be asking if when the buyer agent was acting as a sub agent of the seller.
Okay.
That's not
Okay.
That's not an option anymore.
How do the new rules affect an agent acting as a transaction coordinator with a buyer? This is a great question. Because a transaction coordinator is really just facilitating the deal between the two parties. I don't know that a transaction coordinator is truly representing a buyer, but they would still have to have a buyer agency agreement.
They do have to have a buyer agent. If they're taking a fee or any kind of other remuneration in connection with the transaction, well, they have to have if you're representing a buyer, you have to have a written agreement.
Right.
And if you're getting a fee or any other kind of remuneration, it has to be disclosed.
So if the transaction coordinator was hired by an agent who is actually the buyer agent, then the buyer agent agreement would have to include the transaction coordinator.
Correct.
Jeez. Okay. Is there a split commission? How would the buyer's agent prove that listing agent would pay? Well, you'd have that in writing
Right,
because you'd need to know what that was.
right.
Can sellers not offer any commission to buyer agents? Yes.
Correct, yes.
Would sellers agents be uploading their commission rate split on the MLS? No,
No.
no. And you're welcome, John. John and I go way, 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 way back. NAR needs to go away. Okay. There, I said it. I said it exactly the way I think you meant it too.
Yeah, there was no exclamation point, but you gave
That's
it,
right.
so.
Will there be a new form in place of notice of buyer agency to agree upon compensative from the list side at the time of offer submitted? Notice of buyer agency. Oh, the agency disclosure form. Will there be a new agency disclosure form? I think that's what it's asking.
Yeah, I'm not sure what the ask
Yeah,
is.
me either, me either. Jill, if you're
Sorry.
email me and we'll get you an answer. Can you include in a listing that the seller will pay X% seller concessions, not in the MLS?
Correct.
Not yet. We're really looking at that concession question. But right now we're saying no, but that might change. This is not a question, but the charge of a compliance fee is a bogus charge. Well, yeah, that's been debated for a long time. Mr. Anonymous. Okay, Terry. Whether a listing agent or buyer agent, we just need proper training, best practice and direction and how to follow the rules. You are so right, Terry, and that's our job. And we have to take that very seriously and make sure you get that training and get all the information that we can provide, which is one reason we're doing this. There'll probably be more of these as the rules change and get put in place for sure. Then we'll bring you as much information as we can.
Yeah, I hope we can continue to do these over time, Karen.
Me too, Brian. I was always thinking broker sets the commission rate that their company puts on listing agreements. Did this change? I'm not even going to answer that. No, it's negotiable. The commission is always negotiable. It's always been negotiable with your buyers and sellers. Not all of us use Remind or Transaction Desk for our documents. You mentioned 8/17 is when they'll be available. Some of the third-party platforms will need weeks to prepare the forms. I don't have agreements with any other forms vendors right now that get our forms. So you would need to tell me who that is, because right now we don't have any agreements for them to, pardon me, .loop gets to use our forms. We do have an agreement with them, but that's it. So if it's not one of those three, you'd have to let me know that. Rename the field and make it display only. Where'd that go? Make it display only to hold old data. Easy fix. Yeah. Okay. Maybe there should be a final paid commission field added, especially for comparables and appraisers to consider concessions. That's a really good point too. The other question we have, Brian, is can we publish what the commission was after the sale?
Well, that goes back to we don't know the answer to that quite
Right.
yet.
But that is a question we have in. That's a question we want to ask, Brian.
Yeah, it goes to it goes to a whole like downloading documents in the transaction,
Right.
into Docs Plus, and in other words, we don't know the answer to whether or not searching after having information in the MLS after a deal and being able to search that by brokers and agents, is that going to be perceived as violative of the settlement agreement?
Yeah.
In any way, shape, or form. I mean, I'm hoping not, but we got to figure that out.
The end of the day, Mr. Courtney, does pre-1994 the start of buyer agency policies make more sense? Are we ultimately returning to that era? Maybe. Unfortunately, we don't get to control it though. Can the buyer agreement state the commission as a percentage of sale rather than a flat dollar? Yes,
Yes.
which I would think would be wise. Line item or disclosure. I don't know, Mark. I don't know what they consider those compliance fees. So we do need, it was another question about what can we do with those? So we just need to find out about those. We'll send you, the PowerPoint will be made available to everybody. We have to tell our buyers who is and isn't paying us because it will be on them to pay. That is correct. That is correct, Matthew. Absolutely.
Yep.
Well, I understand what you're saying, that you believe this not showing the commission gives an opportunity for unethical practices. Of course, this is exactly what they were hoping to fix, not cause. So time will tell. Time will tell. You'll know what is being offered when you contact the listing agent and get that information. Agents cannot get a commission from both. They can.
Agents can get a commission from both. It just has to be disclosed.
And it has to only match what's on that buyer agency
And
agreement.
the buyer agent can't get more than he disclosed to the buyer.
If the seller's offering a buyer commission, how do we put that in the PA? Well,
I don't think that should, I mean, it could be in the PA, but it can also be in the, it could be in a seller agreement, in a seller agent agreement disclosed to the buyer agent. It could be in the PA,
as the
but
buyer, as the
it
buyer
doesn't need to
agent,
be in the, it doesn't need to be in the
the
PA.
buyer agent, I think I'd want it in there.
Yeah,
Yeah.
of course. Yep.
So,
But if you had a contract, if you came to me with a buyer, Karen, and I was the seller and I was going to pay you, and my seller had told me they were going to pay me 5% of the sale price, and you and I entered into an agreement that said that I'm going to pay you 2.5%, then we can do it that way. You could do it that way.
yeah. MLS and NAR, the lighthouses of the sea of real estate. Each industry needs a center point of information. That's us. We want to be that for you. Yeah, we need to find out about that, about Freddie Mac and Fannie Mae. Prepare for a lot of, you told me you were paying when you talked on the phone complaints. Yeah, I would want that in writing, Matthew. I would think. Yeah. Could you share compensation info to buyer agents on an email or form when they request a showing on your listing? I would say you could.
Yes,
I would say that would be a good place for it.
that'd be a good place for it. But remember, it just for all the attendees, that's not to have an email is not necessarily a binding agreement. So you've got to decide whether you're going to take somebody on a handshake, on an email, or you need an actual contract.
Is there any conflict with a listing agent allowing an agent from the brokerage to host an open house with the possibility of that agent representing a buyer for that home who doesn't have an agent? Well, you'd still need if you're the listing agent and you get your team member to hold the property open and somebody comes to view it and now they think they want to buy it, you'll need a buyer agency agreement.
Correct.
John is on top of things today. I want you to see this. The VA has recently suspended its rule that buyers cannot pay their agent commission. A permanent rule will be coming later this year. Thank you, John, because I knew something was done that had NAR very excited about being able to get that done. So thank you for finding that. He's quick. Could you share compensation info on an email or form they request? Yes, we already said that. Your seller agrees to offer compensation to the buyer agent. Can we add verbiage to the general comments on the purchase agreement? I would think so. Could they not?
What question are you on?
The seller agrees to offer compensation to the buyer's agent. Can we add the verbiage to the general comments on a purchase agreement?
Yes.
Thank you so much. You're welcome, Carolyn. And thank you again, John. He's even sending links now. I'm telling you, he's on top of things. Do the same rules apply to seller agency working with the buyer as a seller's agent and transaction coordinators? Transaction coordinator is going to be a little tricky. That one's going to be a little tricky because they are going to have an agreement with the buyer.
Yes.
And sometimes transaction coordinators, sometimes they're not licensed. They're just facilitating the transaction. And I think that's going to be an issue. We need to have that. We need to look more into that one too, Fran, transaction coordinators. VA rule preventing buyer agents was suspended for 2 years so they can work. Thank you, Jason. NAR and GMAR fees are included with agents' monthly fees. I don't know about GMAR. And I don't know about NAR because you don't pay those fees to us, you pay those to your board. So that is probably the case. I think for buyers who don't have money to pay agent and sellers not offering commission, the price will go up in order to get paid. Well, maybe.
Yeah, that's part of what NAR argued.
Oh, I love this next question. Will our MLS, you know, the privately held MLS up in the thumb, still be able to have offers of compensation on their website?
They should do so at their own risk.
Yeah, yes. Because I want the answer to be no.
Yeah.
But I don't know. I mean, and it is a risk. Because no, they're not bound by any NAR rules or any board rules, but
They still can be a conspiracy to coordinate between competitors. So
Right.
it'd still violate what the DOJ finds.
right. So
I got an email back from NAR on Appendix C. If you would
Oh,
like me
okay.
to read it.
go ahead. Yes.
We'll also provide this in writing, but
Yes.
let's-
Yeah, I'll forward you the exact email. This is from
Okay.
Mike Rohde, the staff attorney at NAR. Brokerages over 2 billion can elect to complete and submit Appendix C and select an option to opt into the settlement. Appendix C is not applicable to brokerages with a total transaction volume under 2 billion, and he says 2002, but he means 2022. Brokerages under the $2 billion threshold are covered by the NAR settlement if they have an NAR member as principal on the date of the class notice. There are some exceptions if they are affiliated with the other defendants in the 4 operative lawsuits.
So what if, Miss Ann, the broker didn't become a broker and a NAR member until 2023?
Well, then their total sales volume in 2022 would not be above the threshold.
Okay, thank you. All right, so we will put that out there in writing and make sure
Yeah.
everybody has it.
we've
Thank
got
you.
to clarify that for everybody.
Thank you. Mr. Ellier, hi, Mr. Ellier. Here's a link to the latest information about the VA loans. Thank you, Dave.
Thank you, David.
Hello, Tammy. What if you had showed houses for a year to a buyer and there were no sales? Can you write verbiage in the contract that if there was no sale, I think they're looking at having an end date.
Well, there may be a couple of questions here, but
Yeah.
you can have an agreement with a buyer that says you get paid a fee regardless of whether they buy a home or not. You can certainly have that.
Ooh. Oh, to cover your driving them around and.
Yeah, right.
Okay.
You could work for instance, you could work by the hour.
Okay. We're going to Andrea Hackett there, Tammy. Can we remove selling and seller and use buyer agent and listing agent? Can we remove selling and seller? I'm not sure where you want to do that, Andrea. So if you want to, if you want to clarify that for us, that would be great. If, hi, Michael, if Realcomp has to implement the changes to the display of compensation prior to deadline, can we still provide that information in the remarks section up until August 17th? We will gather that information for you and let you know that. I don't want anybody to panic about that. It's just, and I'm sure you understand that when there's hundreds of thousands of changes that have to be made by vendors, as much as I'd like to say, you do ours on exactly this day, sometimes I don't get that authority. So, but I will do the best I can. I'll do.
But
the very
also,
best.
Karen, once we remove the compensation field, we don't want compensation in the remarks.
No, we don't. No, we don't. So we'll do the best we can.
Right. When we implement our new rule, we're gonna stop all compensation in the, I will recommend anyways that we stop all compensation within the MLS.
Well, and we have to listen to you. What about big tech almost creating an MLS? Are there rules to motivate us to be a realtor? Well, I think if you go to facts.realtor, you will see they have a whole section there, I believe, don't they, Ann, about what is the benefit of being a realtor? Because I think that that's a concern of theirs. That you're gonna say, we don't need this anymore.
Yes, let
But they
me,
do have a lot of information there.
it is the last part of the FAQ is all about,
What the
and,
value.
oh,
of
and even
being a
who
realtor.
signed off on the settlement is even on there.
Oh, okay.
So if you have those, that's on there too.
Okay.
So yes, the FAQs, there are 95 FAQs on the settlement FAQs, and there are a couple, there's a separate section for the financing issues.
Okay. Pardon me. Pardon me. Okay. Will there be a commission form for compensation to be signed between buyer agent and selling agent? I don't know that we're going to provide that. Are we, Brian?
I think I drafted one, but I don't know if we decided to provide it.
Okay, so we're gonna have to look at
We will
that.
have one reviewed internally by Realcomp and the board, Karen.
Okay,
Whether or not we choose to include that in our forms, we'll have to determine.
isn't buyer agency a bilateral agreement? Bilateral.
Well, I'll answer by
No, no. It's saying that the buyer agrees to pay the buyer agent
Right.
if they don't get paid. So I don't know that if you consider that a bilateral agreement. Do you?
I'm not sure what they mean.
Okay.
Yeah.
I'm sorry. It's an agreement between the buyer and the buyer agent. It's a,
When you're selling a home and the buyer not wanting to sign an agreement with a buyer agent approaches you and wants to cut out the middleman per se and wants to do the transaction without a buyer agent, as a seller agent, do you have to have a signed buyer agent agreement? Yes. You can never avoid that. Is my understanding. Is that correct, Brian?
correct.
Yes, you still have to have it. Is there sub-agency? We're going back in time, Karen. I don't think any of that matters anymore. Sub-agency means as the buyer agent, you're working for the seller, but that's exactly what they're trying to eliminate. As the buyer agent, you're working for the buyer, therefore you have a buyer agency agreement. Sub-agency was always defined as even if you're bringing a buyer, you're still working for the seller. And I don't
Right.
think
That's kind of that's past passe.
yeah,
But I want to go back up to Bethany's question a minute, Karen.
yes,
I think it really depends if she's saying that she's a seller's agent representing a seller, and a
yes.
buyer walks into the home unrepresented by a agent and wants to purchase that home unrepresented by an agent of any sort. She as the seller's agent doesn't need an agreement with that buyer.
Wow, I would want to look at that, Brian. Are you sure?
I don't know why.
Okay.
The buyer's not paying any, the buyer's not paying any fee, the buyer's not paying any commission.
Doesn't say that. Doesn't say that.
Well, assuming that the buyer wasn't paying a commission.
Yeah, but it does not say that they're not paying a commission, does it?
No, but if the buyer was to pay a commission, then the buyer would need an agreement.
Okay, okay, so maybe that's the difference there. Okay,
Yes.
John is still doing his homework for us.
Does John have a law degree?
I don't know, but I don't even know John, but I'm so appreciative that he's here today. Let's see, practices, settlement shall not prevent offers of compensation to buyer brokers or other buyer representative off the MLS. Concessions on a realtor MLS. Concessions are not limited to, I know. I get it, John. I do. And I know that that's been said, but it just makes me uncomfortable. That a concession, it depends on what the concession is meant to be. And we've really got to do some
Right.
research on that. We've got to do a lot of research on that.
But in general, the concession cannot be a disguised commission
Exactly.
that's somehow paid to the like that's somehow paid to the agent to the broker's agent. It can't be a disguised commission paid to the broker's agent. So for instance, I'll give you for instance that I was talking about with someone else. If you say to the if the seller says to the buyer, we're going to pay for all kinds of home warranties, and then the home warranty companies kick back some fees to the buyer's agent. That is not going to, and all that's published in the MLS. That's going to be violative of this. There can't be, the concessions can't be disguised commissions to the buyer's agent in the MLS.
Right. And I'm going to kind of go through some of these quickly. We will answer all of them. I think, Fran, you'll be able to keep all these questions, right? Well,
Yeah.
I mean, because we're not going to be, okay. So I just want to grab, because we're way past our quit time here. Are you obligated to show if the buyer is, what if there is no commission? You know, this goes to that procuring cause and your responsibility as a listing agent. So your buyer agent says, I can't pay you anything. And the seller's agent says, I'm not paying you anything either. Are you obligated to show that home?
Who's the buyer?
I'm
the buyer
representing the
agent?
buyer. I signed an agreement with my buyer, but they're not going to pay me anything. They're not paying anything, but I still have to have the agreement. Right?
Yes.
Okay. So I know that then I have to collect any money I'm going to make off the listing side. Correct?
Correct.
And so they want to see 123 Elm Street, and the seller and the agent representing that seller says, we're not paying any commission. Do I have to show them that house?
Well, I think that's, I mean, obviously that's a great question.
It is a great question.
And I think it's covered by I think the Code of Ethics speaks to this in certain ways, not directly. But I think that you would, as an agent, under general principal agency law, you would have an obligation to do what's in the best interest of your principal, which is the buyer. So you would have an obligation to show them the home
For free.
for free.
I'm going to speak on behalf of all my realtor friends when I say this. That stinks. That's not right.
It does stink.
That's not right.
No, it stinks.
I don't like that.
And that's why, but it also, these go back to arguments that NAR made in the lawsuits that the whole offers of compensation and cooperation led to a more efficient market and a more, you know, and benefit consumers versus the market that's now being foisted on us, which may not lead to efficiencies and may in fact lead to harm to consumers.
That's not right.
No.
Okay, what about double dip a house? As long as your compensation does not go above what you have agreed to in your buyer agency, you can still represent both sides, can you not? Can you represent the buyer and the seller?
You can represent the buyer and the seller so long as you have an appropriate agreement. It's got to be disclosed. It's a dual agency.
If the buyer is unable to pay commission, do you put language in the buyer contract that try to negotiate commission with seller? If seller will not pay the commission, then they will be unable to collect a commission. Also, is it difficult to know in advance of negotiating sale whether seller will pay part of commission?
You could say in your contract with your buyer, I'm going to use my best efforts to get a commission, to get the commission paid from the seller or the seller's agent. But in the event that I am unable to do so, you will pay me $5,000.
Right.
You can do that.
Yeah. I'm sorry, Dimitri, that I missed the second part of your question. What if the buyer, remember, looked at the same house with two different agents? Well, then you'll have to take your complaint to the board, and the board will have to decide the procuring cause action. That's no different than it is today, correct?
Correct.
There's an actual notice of buyer agency form that shows a percentage or dollar amount of commission seller will pay. Are we able to still use that form? I'd have to see that form.
Yeah.
It's just gotta
Oh.
be clear and, or objectively ascertainable, you know, don't leave a blank.
And yes, we do have an agreement with Loop for our forms, so we will get them to them as well. The Michigan Association of Realtors has a form that is entitled Notice of Buyer Agency. This question likely should be directed to Mark. It's a question I have asked myself, but regardless, want to clarify that there is indeed a Notice of Buyer Agency form that is different than the disclosure of real estate agency relationships. Excellent. Thank you, Jason. Are realtors required to report commission amount to Realcomp even when we can't list it publicly on the MLS? No, you are forbidden. You are absolutely forbidden from reporting it to Realcomp. We can't see it. You know, Don, I don't know. He's asking, why can't the commissions be in the MLS? What better way to show that they're not the same? I don't know how to answer that. What happens if the buyer agrees to pay a certain amount to the buyer agent, and once a closing is set, the buyer cannot afford to pay, but has enough to buy the house and wants to go forward with the purchase, but tells the buyer agent, we can't pay you? What will happen? Would they not have to sue them?
Have to
Right?
sue them under the contract, correct?
You'd have to call Brian or Ann. Do you think there's a liability if a non-licensed realtor started a website that lists commissions publicly? I think you'd have to be very careful where you got that information from, but I don't think I could answer that.
It's a business opportunity for John.
If you opened up a website that says, you know, get paid here, I don't know. If Realcomp does not feed into Zillow, an agent puts the listing on Zillow, can compensation be posted there? No, Zillow is a brokerage. They are one of our customers, just like all of you, and they have to follow the same rules. What happens when you enter into an agreement with a buyer to pay the commission and then at closing the buyer refuses to pay? Well, again, you'd have to sue them. I'm sorry, but
Yeah.
are we saying the whole agency disclosure and laws are obsolete now? No, we're not saying that. You do have to disclose who you represent. Correct?
Correct. No, they're not obsolete. They're more,
No.
they're actually being
And
more,
they're augmented.
they're
Yeah.
augmented and being more focus on them.
Yeah. Okay. Well, you know, 158 of you have been extremely loyal and stuck around, and we will make sure that all of these questions get answered, and we will get them posted, and we'll get the additional information. Anne already gave you the information about the Appendix C, I believe it is.
Large brokers only.
Yep. And then we'll get the other information. Now, as far as forms and what we can have on our forms and what we can have in our library, what we can't, that might take a little bit more time. I'm thinking that the reason we're not getting an answer from NAR is because frankly, they don't know. I don't think they know how to answer it.
I would say that that's exactly right, Karen.
So Anne, thank you so much. Everybody say bye to Anne. She's leaving us as of tomorrow, and she won't be advising us anymore. So good luck. And Brian, thank you so much for taking your time today to do this. I really, really appreciate it. Thank all of you for participating. We will do this again, and we'll have more information, and we'll have more answers, and we'll field more questions. You can, if you have specific questions you didn't get on here, you can send them to me. You can send them to support. Either way, we'll make sure if you send them to support that they know to forward them to Fran and I. And I was so neglectful for not saying that Fran is here running the behind the scenes for us. Thank you, Fran Green. Fran is always here running.
Thank you, Fran. Thank you, Fran. Fabulous job. Fabulous job.
Thank you.
So, everybody have a great day, and don't worry, we're gonna get it, we're all gonna get through this. We're gonna help the best we can, I promise. Stick with us and we'll get you there. So thanks, everyone.
Thank you.